This is one of those questions that naturally leads to the "it depends" answer that attorneys are faced with or usually tender. Not a very satisfying answer. If you have money in a savings account, a few $100s, and you take money out, that's really not going to be a problem. The problem arises when it's a lot of money. Now, one of the things, at least in the Central District of California, that we are required to do after we file a bankruptcy petition is send to the trustee associated with the case or assigned to the case bank statements. Different trustees require different amounts of bank statements. Some just want the last 3 months, others want more. And if it's a complicated case, you might even be required to send to the trustee something on the order of a year's worth of bank statements. The trustee is not getting these statements just for fun. The trustee will go over these statements very carefully to see if there were large sums of money that were transferred back and forth. Now, let's think again in the Chapter 7 context first. What's going on in the Chapter 7? Well, you remember I said we're just wiping debts out. So there are limitations. And one limitation, of course, is what you get to keep. So we get to protect what's exempt using the appropriate exemption table. Anything we can't exempt, the trustee gets to take. Let's say you have $45,000 in a savings account, and a couple of weeks before filing that bankruptcy petition, you took the money out, and you didn't tell your bankruptcy attorney about that, although if the bankruptcy attorney is any good, when he or she looks at your bank statements, so that big withdrawal will be present. But in any event, you decide you're not going to list that cash that you just have sitting in a sock. Well, when the trustee takes a look at that bank statement and sees you took $45,000 out, the natural question is, where'd the money go? Can you exempt that money? Probably not. That's a lot of cash. And so now you've created a real problem, because if you didn't disclose that either as money in the bank or cash on hand, you have concealed an asset. Now, why is that a big deal? Well, it turns out that when you sign your bankruptcy petition, you're going to be signing it under penalty of perjury. And one of the things you are going to be assenting to is, I listed all of my assets. And if you didn't list that, you have committed perjury. Now, the good news is you'll eventually end up in a federal penitentiary as opposed to a state penitentiary. I don't say that experientially. I've never actually been in a penitentiary because I've never taken a criminal case. But I have had some bankruptcy clients who, prior to becoming my bankruptcy clients, had, in some cases, spent years in penitentiaries. And they have assured me that the food is better in the federal penitentiaries. But rather than doing something like that, generally speaking, it's a better idea to do some very careful pre-bankruptcy planning. So when you start willy-nilly taking money out of accounts, that can really raise some red flags. Where is the money going? If you don't have something to show for it and you can't exempt that thing that you have to show for it, the trustee gets to take it in a Chapter 7. And as I said earlier, the value of that asset will go into determining what your Chapter 13 plan payments are if it's a non-exempt asset. And while I didn't get into the weeds in Chapter 11 in the previous question, a similar sort of analysis happens in Chapter 11. That Chapter 7 liquidation requirement does apply within the Chapter 11 context as well. Now, there is yet another thing that can happen. You take money out of that savings account. Again, if it's a couple $100, nobody's going to care. But let's go with that $45,000. Well, you took that out and it's all gone. Where'd it go? Well, I gave it to my kids because they're nice kids and I love them. Well, isn't that nice? That's a fraudulent transfer. And anytime you transfer to a family member, that's a special kind of person called an insider. The presumption is it's a fraudulent transfer, that you didn't get a reasonably equivalent value in exchange for the transfer. That will raise all kinds of red flags as well. Generally speaking, it's a very good idea to talk to a competent bankruptcy attorney before you file to see if there are some of these problems that can be addressed prior to filing. So be very careful. The bankruptcy system is designed to give the Poor but unfortunate debtor, a fresh financial start. It comes down hard on debtors who try to scam the system. Now, occasionally I'll have somebody say, well, wait a minute, you're saying I can't give my kids a gift? Of course you can. But if you have creditors, that changes the dynamic. If you have no debts, you're free to do anything you want within the bounds of law with your money. Now, that doesn't mean that you can engage in criminal activity, but yeah, you can give gifts to anybody you want if you have no creditors. But if you have creditors, that changes the dynamic pretty significantly. So be very careful about transferring stuff.